Hello, everyone. My name is Lonnie Woods III, and I am the Professional Development Coordinator for the Arts Administration Program here at Teachers College. I'd like to thank everyone for joining us today for our Employment Visas in the Arts Amid COVID-19 event, led by Raquel Milstein, founder and CEO of Milstein Law Group. This webinar is co-sponsored by the TC Arts Administration Program and the TC Alumni Relations Office. Today, Raquel will discuss the H-1B and O-1 visas, their benefits, and how students and alumni can best prepare for them. Before we get started, I wanted to remind you that there will be a question and answer period towards the end of the webinar. Feel free to add questions to the questions pane. Now, I'm going to introduce today's facilitator, Alexis Yoon. Alexis Yoon is the founder of the Art Diplomat, an art advisory dedicated to promote social change through the art events, curating, and partnership development. Prior to that, she worked for the auction house Christie's in London, developing their Chinese art business. Then at Art Basel in Hong Kong, where she was the founding team member of Art Basel Cities, Buenos Aires. Alexis is a graduate of the Arts Administration Program and an advocate for international students. So I would like to welcome Alexis.
Thank you, Lonnie, for the introduction. And thank you, ARAD and TC Alumni Relations for organizing this event. It is so nice to be here as an alumna, and I know this will be truly helpful to our international students and community. So it is my honor to introduce our speaker today. Raquel Spire Milstein has been working in the field of U.S. immigration law for nearly 20 years. Her law firm, Milstein Law Group PLLC, focuses on the business immigration law with a specialty in O1 and EB1 extraordinary ability cases. She has worked with thousands of talented individuals ranging from all aspects of the arts, sciences, athletics, business, and everything in between. Additionally, her practice handles green card applications for family members and for employees. She has challenged the government in federal court on many occasions, resulting in the granting of overdue benefits to our clients. As a zealous advocate for immigration clients, Ms. Milstein is passionate about her work and is eager to share the intricacies of U.S. immigration law to foreign nationals, especially foreign students embarking on their careers in the U.S. So let us welcome our speaker. Thank you, Raquel.
Thank you, Alexis. It's a pleasure to be here, and thank you for having me. I wanted to present some information regarding temporary work visas available to recent grads or anyone who has a graduate degree. I would like to start with discussing the O1 visa. It's important to note that there really is only a handful of work visas available in the US, and the O1 visa is one of the best options out there. It's reserved for people of extraordinary ability. It has a very daunting title, but in fact, many people can qualify even though they may not think of themselves as extraordinary based on the criteria in the regulation. The O1 visa is often referred to as the artist visa, but in fact, it's available to all professions, including athletics, business sciences, administration, and more, and on and on. We've worked with people in the arts in terms of curators, art critics, multimedia artists, all types of visual artists, from performance artists to visual installation artists and arts management coordinators who work in galleries or museums or nonprofit arts organizations, as well as auction houses. And then obviously this would also apply to graphic designers and many others who may have tried to file an H-1B and was not necessarily selected in the lottery. So it's a great alternative and a plan B for those who did try for an H-1B but were not selected in the annual lottery. Just to give you a basic overview, the O1 visa is a 3-year work visa, and it can be issued in smaller increments, and the duration of this visa is completely dictated by the job offer. So if your employer offers you employment for 1 year, this will be a 1-year visa. If they can offer you a 3-year contract, then it becomes a 3-year visa, also similar to the H-1B. The O1 visa involves a lot of preparation, and so these cases can take on average about 3 to 6 or 7 months from start to finish. We prepare the case within about 3 to 4 months because it involves a collection of a lot of evidence. The evidence is the focus of these cases. So to break down the O1 visa requirements, it's important to note you must have a US petitioner. And in the context of most work visas, the US petitioner is traditionally an employer. So if, let's say, a museum is sponsoring you for a work visa in the future, regardless of whether it's an O1 or an H1B, the US petitioner would then be the employer. But there are different ways to set up an O1 so that you can work for multiple employers, and that's actually one of the beauties of the O1 is its flexibility. So we'll discuss that in a little bit, but you can set up the US petitioner to be either a US employer or what we call a US agent. And a US agent is in fact any US citizen, US green card holder, or US company. The term agent sometimes throws some people off because we think of talent agents when we hear that term. But when you think of the function of an agent is someone who links you to something. So a talent agent links you to job opportunities or auditions or things like this. An O1 agent would simply link you to the immigration service, and that is really all the requirements involved. So you need one US petitioner, you need evidence of future work offers, and these are not necessarily binding employment agreements. What suffices with immigration are even letters of intent to reflect your future plans. And this is important because it's sometimes difficult to know what you will be doing 3 years from now. But if we have a letter of intent that reflects your plans, which are subject to change, that is acceptable by immigration. And so that way you're able to collect maybe more letters of intent from various employers who are more willing to sign off on an intention rather than a binding agreement. Now, as I mentioned previously, the evidence is really important for these cases, and evidence, I'll go into the details in a minute, but generally consists of objective evidence that was available at the time of your achievements. For instance, if it's an exhibition that took place, the evidence of any reviews in any newspapers or magazines that were issued at that time, any brochures, pamphlets, write-ups, anything that was issued at the time of the event. In contrast to the letters of recommendation, which are also they play a big role in the O1 petitions, but those are clearly created at the time we're preparing the O1 to help discuss how your work has been instrumental or critical to the success of certain projects, events, exhibitions, productions, etc. So the way that the O1 petitioner, as I said, can be a US company, a US citizen, or a US permanent resident. And the case is signed, we prepare the case, and all the paperwork is signed by the petitioner. So you have to think of them as, if it's not an employer, a US rep or a US point person. The idea is that if immigration would like to get in touch with the O1 visa holder, they can reach out to your petitioner, and your petitioner can then connect the two of you. Very rarely does this occur, but in this climate where we're seeing a lot of events that have been temporarily postponed or canceled, I have been hearing of instances where immigration officers are calling petitioners to verify whether or not certain events are continuing to take place. So one important note is when you're selecting your petitioner, you really want to pick someone you can trust. It matters more that you trust this individual or company more than whether or not they are in your field or are very prestigious in your field. So your petitioner can be the employer or as an agent, and you can have one single petitioner, or you can have the agent that would represent you for multiple employers. And what I've seen in my practice is most people want to have a multiple employer O1. It's definitely a safety net, because should you decide to leave even your main employer, a full-time employer, you have these other employment offers that you're able to take on without necessarily notifying immigration and continuously filing amendments with the immigration services, which can clearly be costly and time-consuming. So the standard for the O1 is clear in the regulations, and essentially you must have a major award, or you must satisfy 3 out of 6 criteria. Most people don't have the Nobel Prize or the Academy Award. We've definitely worked with people with Emmys and Grammys and Academy Awards, but generally the O1 focuses on establishing 3 of the 6 criteria for most applicants. So I've broken down the 6 criteria as we see them, okay? So I'm going to go down each bullet point to help you understand how we approach them and how they differ. The first criteria actually has 4 parts to it, this first bullet point. We have to demonstrate that you have and you will perform a lead or starring role in productions or events which have a distinguished reputation. So we have to show that you have performed a lead role for an event that had a distinguished reputation, and that you will be. And one challenge we see with this criteria is trying to flesh out how the individual performed a lead role, and then also trying to establish a distinguished reputation for, let's say, an event that has not yet occurred, right? An exhibition that has not yet taken place. How do you document it already has a distinguished reputation? Now, we generally submit evidence in the following ways. We submit evidence, let's say it's at a prestigious gallery. We provide extensive evidence regarding the prestige of the gallery, prior exhibitions they've held, and artists that they have shown. And then we usually couple that with a letter of recommendation from either someone involved in the gallery or who was involved in the actual exhibition as a whole. So that way we tackle the lead role and then the distinguished reputation. Now, if you look at the bullet point 3, the third bullet point, you'll see there's a lot of overlap between these 2 criteria. And the main difference is that we have to show that the critical role was for an organization or establishment versus the actual production or events. Well, how are those distinct or different? Generally, the first bullet point deals with an individual, let's say exhibition or an individual project. Even if you're, let's say, a writer, an individual publication, that one publication, not the whole publisher as a whole. So when it comes to organizations and establishments, we have to demonstrate your leading or critical role for that organization or for that gallery or for that museum. And that becomes a little more challenging because in today's climate, the immigration services are looking to see where you fall in relation to the CEO and all the executives at the organization, when in fact it's been interpreted quite differently. So we generally combine these 2 criteria and argue them together because there's generally a lot of overlap between, let's say, one particular exhibition and actually the gallery. So those 2 work well together. National or international recognition is a great category. This can be demonstrated through press or media by or about the artist or individual. So what that means is if you're someone who frequently writes or publishes work in any sort of journal or publication, you can satisfy that criteria through your own authorship of publications. Another way to do it is submitting press about you, which is a little more challenging, right? But there are many people who go out and find people to write articles on them or promote themselves in a way so that they're getting much more media attention than they normally would. This is an excellent way to prepare for an O1 case, because you want to show that you have received recognition in your industry. And if you can do so by publishing your own works or by reaching out to journalists or organizations to cover some of the work you've done or the projects you're involved with, that is excellent. Immigration loves to see articles. It's objective evidence. It doesn't make them think twice. They don't look to see whether this was created for the purposes of the O1. They love this type of evidence. Commercial or critically acclaimed successes, which is the 4th bullet point, is also a great category, not necessarily used very frequently with arts cases, but certainly with all types of film cases and things like that. We have to show commercial or critically acclaimed successes through experts and reviews from critics. A lot of times in terms of the commercial success, they're looking at financials. So any works of art that have been sold or commissioned for a significant amount of money, that's one way to satisfy that criteria. Or if it's an event where ticket sales, were extensive, and we can show that there's say a performance that had that was sold out, we can document those elements that way. Significant recognition for achievements from organizations, critics, government agencies, and other recognized experts in the field relies nearly entirely on letters of recommendation. So this is one category that anybody can try to satisfy as long as you can obtain strong letters of recommendation from recognized experts in the field. And what they do is they talk a bit about their own background to show their own level of expertise. And then they provide information regarding their opinion of you and your work and your achievements specifically. And then, similar to commercial or critically acclaimed successes, a high salary or other substantial remuneration for services in relation to others in the field is not one that I would say is frequently used in our arts, with our arts clients, but we have done it. So working at auction houses definitely helps. And so if you're working in an organization and you do have a high level position, it's certainly a way to satisfy that criteria. It's important to note that it could be prospective. So we don't need to document you are already receiving a high salary. If you have a great job offer and you're going to be paid substantially more than others in that position, then we can argue that as well. And clearly that's a less discretionary criteria, and immigration officers are more likely to grant that. So, as I mentioned, evidence is the key to an O1 case. I essentially break the O1 into two components, and about 90% of the case really relies on your past achievements and successes, which we need to document through objective evidence. The remaining 10% would focus on your future work to be done in the United States. So the best thing you can do if you're considering applying for an O1, which I think everybody should do because there are ways to make your case happen, and I've seen it so many times, is to get your name out there. These O1s are for people who've received recognition in the field. You are promoting yourself, you're promoting your work, and you can do that either vocally or you can do that through, like I said, publishing works, writing, exhibiting more. So types of evidence: publish reviews of your work, performances, and exhibitions, clearly objective. And the more prominent the publication, clearly the more consideration the immigration services will give to that article. So having a review on a blog that doesn't have a lot of followers is not going to be a good piece of evidence. Having a review in the New York Times, obviously amazing, but most people don't have that opportunity. So you want to consider what is the publication, and the larger the circulation of that publication, the more readers, more viewership, the more consideration an immigration officer will give to that review. If you have contacts to publications back home, some of my favorites are, I work with a lot of Singaporean nationals, and especially some who are in the musical theater field, and their musical theater industry is relatively young compared to the US's. And so to reach a high level in your field and to show that you are getting reviews, getting a national review in Singapore is quite easy because you have, one city, one country. And so it's a great kind of angle to take if you can reach out to sources back home and you're from maybe a smaller country or even a larger country like China, right? So if you have an article written about your work in even a local publication, that publication may reach many more people than a local publication in the United States, right? So we can demonstrate that it's a well-known publication because there are many readers, and even if it's local circulation. But generally, they want to see the national or international publications, which is not always used. As I mentioned, published work in your field. Now, you don't want to submit self-published work because immigration doesn't give much consideration to that. They're also starting to catch up with different types of media outlets. For instance, if we submit an article you had written in medium.com, they now know that anybody can publish an article in medium.com. There's not a high level of expertise needed to get your articles published on that source or on that website. So they are starting to do their own research. They tend to Google you as well. So you want to make sure your LinkedIn's, your IMDb's, your whatever profiles you have online are definitely built up and contain all the achievements and all the work you've done, because they do their own outside research, even though they're supposed to limit the review to the record. The best type of evidence, in addition to the press, is awards or prizes. Again, objective. There's not a lot of discretion involved from the officer. So if you have a major award or prize, this is going to be excellent for your case. Now, there's a caveat to this, and it applies to all the evidence that you submit for an O1, which is that it has to be awards or prizes or publications. All the evidence has to be outside the academic arena, okay? Immigration's point of view is that if this is a piece of evidence or an achievement that you had that was while you were a student, then this opportunity was only available to students and it wasn't available to all professionals. So it's not a fair assessment of your actual achievements in the field, because the O1s are for professionals and not for only students. So keep that in mind. If we're going to get awards or prizes, I would say enter competitions, online competitions, maybe competitions you weren't interested in generally, but it would help your case. Do it, because the more awards or prizes you have, the stronger the case. And this also holds true for exhibitions and art shows. You want to do as many as you can, and in this climate, doing any kind of online exhibitions would also suffice for the purposes of the O1. Letters of recommendation, I mentioned that from experts in your field. So many times people will come to me and say, well, I have an excellent resource, but he was my professor at school, can he give me the letter? Absolutely. As long as the individuals can speak to your professional achievements and accomplishments, then you can use a letter from one of your prior professors if those are one of your best resources, because they clearly must be well established to have this sort of role at this university. So certainly we can use professor letters so long as they only discuss your professional achievements. I mention this because we're not trying to hide anything from immigration regarding your student status. They have your F1 visa information or J1 visa information. They know you're on a certain status. But when we include evidence of student achievements in the petition, what happens in practice is the officer gets suddenly distracted and starts to question all the evidence and casts doubt on whether or not these are all actually professional achievements. So it's just a good idea to try to eliminate all student-related activities. However, I just want to mention that if you create an artwork or a film, for instance, while you're a student, and that piece of art or that film is then exhibited or screened at a professional event, well, then that's still counted. So it's not about whether you were a student or not when the piece of work was created, but more whether or not the recognition is for something that was available to all professionals at the time. And then the commercial successes, like I had mentioned, is documented through box office. You can see how old these regulations are: box office receipts on or record, cassette, compact disc, or video sales. I like to include those details because that's exactly how the regulation reads. And you can see, I mean, we're in dire need of having some updating to immigration laws, certainly not in the way that the Trump administration has been moving forward, but a lot of these laws are outdated. So it's on us to really present clear evidence to satisfy the criteria, even though we have dated samples of evidence. So for instance, any newspaper article that we submit, we also have to submit evidence, independent evidence of the circulation information. So that's how we kind of satisfy that part with the newer media. Okay, so that's really before I get into the H-1B, I mean, that's really the nuts and bolts of the O1. So it really is focused on the individual's achievements, and and knowing what you can collect now moving forward is essential to building your case. I've met with so many people who aren't yet ready for the O1 based on my review of their evidence, and then they go out there for the next 6 months to a year and they promote their work, they promote themselves in these ways, and they have an excellent O1 case only, sometimes even 3 months later. So it's definitely a good idea to prepare that way. The next topic is the H-1B. And the H-1B is probably the most well-known temporary work visa out there right now. And before I go into the slide, I just want to let you know that originally when the H-1Bs began, they were created to actually deter US employers from hiring foreign workers. So I want you to know this because there are components to the case that are just excessive on the employer sometimes, including the amount of forms, paperwork, salary requirements, and fees to the government that are involved. So what I've seen in the last 3 years in this administration, almost 4, is that The H-1Bs are being heavily scrutinized, as are many cases, but the H-1Bs have been particularly, are taking a particularly hard shot lately. And what matters, and I think this is essential for current students, is the type of degree, the major you have. It is essential to the success of an H-1B case. For instance, there's plenty of clients who I've seen who have gone and gotten a business degree or a business management degree. And while they think this is a great idea for their careers, it's actually not very useful for an H-1B. Or for instance, there are schools that don't even have majors, like I believe it's like Sarah Lawrence, where they just get a liberal arts degree. But part of the H-1B requirements is that you have a degree in a specialty occupation and that you're getting hired for a position that requires this degree in this particular specialty occupation. So if an easy example is, if you're an economist and you get hired, if you have an economics degree and you get hired as an economist, right? That's a slam dunk H-1B case. It's easy, it's great. In the fields of arts and arts management, you want to ensure that you're majoring in a field that would require at least that degree for the job. So for instance, a visual artist does not qualify for an H-1B generally. I'd say 99.9% of visual artists who would apply for an H-1B would be denied, because based on the standards of the Department of Labor, they say that a degree is not required to be a visual artist in the US. So it's an impossible argument to make. So so the H-1B, in terms of preparation, it's essential to really try to figure out what degree may work if you really are interested in staying in the US and pursuing an H-1B post-graduation. That major is essential. Another quick note is that administrative positions are not generally considered H-1B specialty occupations. So working as an executive assistant or any type of administrative assistant are impossible H-1Bs as well. So how do we get around some of these issues? Well, we can work with people in arts management who have more managerial type of expertise, or operations management, or writing background. There's definitely being a writer is accepted, or an editor, a curator. Those are all acceptable H-1B positions. So it's a consideration when selecting a major in terms of H-1B qualification. And the type of employer is important. The H-1Bs have an annual quota of 65,000 H-1B spots a year, and that is for for-profit companies and organizations. If you have a master's degree from a US institution that's a nonprofit school, you have an additional 20,000 H-1B spots for the year. Now, what happens in practice is that clearly more than 65,000 or 85,000 applicants apply for the H-1B annually. And over the last 5 years, there's been this annual lottery, because there have been, last year there was, or this most recent lottery, there were close to 300,000 applicants. The years before, it was around 200,000 applicants or more. And so the Immigration Service ends up doing what's called this annual lottery. So they give a number to each petition that is submitted around April of each year. They then do a lottery, and then those who are selected find out that they were selected. That doesn't mean you're approved. That just means you're selected for processing. Then once it's selected for processing, you are you do have to show that you meet those criteria, and that's when that major is really important, or that specific field of study and how it relates to the job offered. With nonprofits, there's exceptions, and this is really important for the arts world, because if you're working for a museum or an institution of an academic institution, there are ways to file H-1Bs where they're not subject to this annual quota. They're exempt from it. Certain nonprofits that are primarily engaged in research, and nonprofits that have affiliations with schools in the US can also be exempt from this H-1B quota. So there are many opportunities out there. I know nonprofits and for-profits have their own policies in terms of sponsoring H-1Bs, but that's not across the board, right? It's really specific to each organization and each company. So something to look into, or speak to someone there to see what are their hiring policies when it comes to H-1Bs. But the beauty of the nonprofit exemption is that you can apply for the visa at any time of year. You're not subject to having to find a sponsor for your H-1B before April 1st. As a side note, this year in 2020, the Immigration Services implemented a new electronic filing system. So the lottery took place prior to April 1st, but for the past decades, it was always on April 1st. So this year, what happened is they have a new electronic lottery, and submissions were sent in through the computer electronically, and we found out the results before April 1st. And then there's the salary requirements. So the Department of Labor has a site that dictates what's the minimum salary for the position. There's a 4-level tiered wage, and depending on how much experience you have, what types of degrees you have, it would dictate, what level you're at in terms of salary. In this Trump administration, they're giving people a hard time if you're making only the lowest level salary of this 4-tiered wage dictated by Department of Labor. So many immigration lawyers are advising that if you are going for an H-1B, you don't want to necessarily go for the lowest wage. Of course, that's ultimately the decision of the employer, but it's a consideration because they're just harping very much on the salary requirements. Salaries can be found online. They're accessible to everyone. It's a site called flcdatacenter.com. It's very user-friendly. You put, there's drop-down menus, put down the location, and you can kind of get a gauge as to what kind of salaries are required for these H-1B petitions. And they don't have to be full-time, and this goes for the O-1 too. The H-1Bs and the O-1s can be for part-time work in the US. And so in terms of salary, they look for the hourly wage. So if the salary is much too high for the nonprofit to agree to, sometimes they'll offer you a part-time position on an hourly basis that would then satisfy the Department of Labor criteria. Okay, so with the H-1B, as I mentioned, they were created to deter US employers from hiring foreign workers. So one of the requirements for the H-1B, and this does not apply to the O-1, is that the employer has to pay all the immigration fees involved with the case. And there are several immigration fees. With the O-1, there's one immigration fee. The immigration fee for all employment-based temporary work visas is $460 right now. I'm sure it's going to go up because there's all this publicity about how immigration is running out of money this summer, but we'll see. But for now, all non-immigrant work visas require a base fee of $460, and in the H-1B context, the employer has to pay it. H-1Bs have an additional $500 fraud prevention fee that's required, and then they have an additional $1,500 fee if the employer has more than 25 employees. That number's cut in half if they have 25 or fewer employees. So those are a bunch of additional fees they are imposing on the employer. The employee cannot pay for the immigration fees. There is no specific restriction in terms of the legal fees. So some attorneys take the view that all fees must be paid by the employer, and others say, well, it hasn't really been specifically addressed in the law, so the employees can pay the legal fees to the lawyer, but the employer must pay these immigration fees to the Immigration Services. As I mentioned, the degree or equivalent, it must be closely related to the H-1B position. So if the position is a general, let's say project manager, we get a lot of those, we have to somehow figure out what is this actual position. The way the law reads with immigration is it's not supposed to be about the title. They're not supposed to base anything on titles. The Immigration Services are supposed to review only the duties. So regardless of what title your company wants to give you, they focus on the duties. But again, then there's the actual practice and how we see things in reality. And if we submit a case for an H-1B that has a title that says some sort of assistant or some sort of manager that's general, it's a much more difficult case. It's not impossible by any means, but it's good to have a well-tailored job title that matches the duties so that these officers don't get flustered and can easily process the petition. I mentioned the timelines. The reason why April 1st has been the date of filing of all H-1B petitions is because the fiscal year for immigration begins on October 1st every year, and you can apply for a work visa 6 months before the start date. So all H-1B petitions filed annually subject to this quota are for a start date beginning October 1st. So for instance, when you are on your OPT and you have a job offer, and let's say we file your H-1B on April 1st, it's selected in the lottery, well, your OPT generally ends in the summers. Of course, there are exceptions and some in different times of the year, but for the most part, they end close sometime in the summer because they're issued around the time of graduation and they're issued for a year. So what would happen is the OPT, let's say, would expire July 1st, but your H-1B only begins October 1st. Well, the Immigration Services created what's called this cap gap. So if your H-1B is selected in the annual lottery and for processing, and you haven't received a decision by the time your OPT expires, you're actually given an extension of your OPT through till September 30th. So there's no gap in employment authorization. So you can have continuous work. The only issue is you don't want to travel internationally during that period of time because sometimes people have issues re-entering and it could break that cap gap benefit. And then the next bullet point is about these 20,000 additional H-1B spots for the master's degree. So before getting into COVID, because I'm sure there are a lot of questions about the impact of the current situation and how immigration and consulates around the world are handling cases, I did want to mention just a few alternatives to the H-1B and O-1 for those of you who are from, I believe, Chile, Mexico, and Canada. There are alternatives, and there's also another one for those from Australia. But there is something called the H-1B1, and that is for people who are nationals from Chile and Singapore. The H-1B1 is very, very similar to the H-1B in terms of requirements. A couple of distinctions is the duration. So the initial H-1B is issued for 3 years if you have an offer for work for 3 years. Whereas in Chile, the H-1B1 is valid for 18 months. And for Singaporeans, it's a 2-year visa. Another distinction is H-1B1s require what we call temporary intent, which means that when you come to the US and you're going through immigration at the airport, you have to demonstrate that your intention is only to come to the US temporarily for this position, and you have every intention to return home, meaning you're not filing a green card application. The H-1B is different. It allows you dual intent. You can have a pending green card application, and you can also be someone who wants to return home. You don't have to show the temporary intention as you do with an H-1B1. And then there's another alternative for those from Mexico and Canada, and that's called the TN visa. It is similar to the H-1B, but it's different in that TNs are only permitted for those who are filling a position on a specific profession list. And the profession list is, it's not that long, it's not that extensive. I think the only art-related field would be a graphic designer, or maybe an industrial designer that is on this list. But for them, and there are teachers that are on this list. So if you are not filling a position on this TN profession list, you cannot qualify for a TN. There are some areas that people are creative with. For instance, there is a profession called the technical publications writer. So there are some individuals from Canada and Mexico who go for this. If you're writing for arts organizations with anything to do with any technicalities regarding the organization. Some people in PR have also come in on that type of category because their job does involve extensive writing and details about their policies and things like that. Another one is a management consultant, and that's another category that's heavily scrutinized by officers who are reviewing TN applications, simply because it's the only TN profession on the list that does not require a degree. It requires either a degree or 5 years of experience in the field. So a lot of people go for that if they didn't receive a degree. Okay, now moving to COVID. Things are changing daily. So when this was prepared, it might, things may have changed, but we'll go through these bullet points. First of all, the USCIS is open and processing cases regularly. We've been working remotely since March 13th, but regularly filing cases, shipping them to immigration via FedEx, and receiving approvals constantly and receipt notices. So the Immigration Services has not closed. They have not slowed down. In fact, I've seen faster processing times in 2020 than I've seen in the last 4 years with many cases. So they're open, they're running. The only issue is they have currently suspended in-person appointments through June 6th. However, they announced yesterday that they're going to be resuming them after June 6th. And that's based on the particular location, right? So if New York State still has us on shutdown or lockdown, well, then I don't see the Immigration Services able to reopen their in-person appointments. In-person appointments generally are for those applying for naturalization, green cards, those who need to go in for a fingerprint appointment or things like that. So it wouldn't affect you if you're applying for an O1, an H1B, or any other type of temporary work visa. In terms of the consulates, this is for those who are outside the US right now, this is where we're feeling the impact of any changes from COVID, because the consulates and embassies worldwide have been temporarily shut down for a few months. Now, a lot of them are reopening or have reopened and are accepting visa appointments. I've heard of some people who have appointments scheduled for June 1st in Sweden, and I have clients who were scheduled for visa appointments in June and were just recently notified they've been postponed till August. This is something we have to watch on a day-by-day basis because it's just changing constantly, but also based on each post, right? Each city and each consulate has their own details regarding what their opening procedures are and when they're going to do that. So just know that. And it's important because a lot of people who are overseas want to come back to go to school. If you already have your visa stamp, you're great, you're in good shape. But if you don't, we're hoping that the visa services will reopen fully by August. But again, we have to wait and see. Regarding the recent Trump proclamation issued, it only applies to those individuals who are applying for immigrant visas from overseas. And in fact, it really didn't change anything that was already happening. I think it was just Trump making this formal announcement. But what was happening already in practice, like I had said, is that these consulates were already closed, so they couldn't issue visas due to COVID-19. So Trump said, well, you know, we won't allow these individuals to apply for these immigrant visas, but they can't anyway because the services were closed. So the one thing to keep in mind is he left a window open, and there's a lot of talk about whether or not he's going to also further restrict immigration in terms of non-immigrant visas. And I've been reading the news like everyone else, but there's no official update yet, but I've heard something. We may hear something this week. I wouldn't be surprised if we hear something at 7 p.m. Friday night that he's expanding this. Right now, I'm only reading articles that seem to pertain to the J1 visas and possibly OPTs. So we're going to keep a close eye on that and see how these cases are impacted. So we're going to wait for these changes, and hopefully not much more will happen, but we'll see. One last comment that I wanted to mention for all these work visas is that there is generally a process called premium processing that is an expedited service with immigration. They issue a decision within 15 calendar days. They've been temporarily suspended. This happens almost every year, and I assume or expect that immigration will resume premium processing before the end of the summer, specifically, you know, in preparation for the academic school year to begin, because they do want professors and experts to be able to get their visas to come and teach and work who don't have them already. So hopefully we'll hear some update on that as well. So that is the nuts and bolts of the O1 and the H1B in the climate of the COVID-19. Thank you.
Thank you, Raquel. That was extremely helpful and really relevant to these times. So it's now for time for Q&A, and thank you for those who already submitted your questions ahead of time. I see that Raquel has addressed many of them, and we will go through the rest of them now. And if any of you has any additional questions, please submit them in the action pane on the right. So the first question is a direct one about fees. You've mentioned the fees about H1B. What are the fees for O1?
The O1 immigration fees are $460. And that's for regular processing. As I just mentioned about the premium processing, many people select premium processing because it's the only way to get an assurance of a specific processing time. So regular processing can range. We're receiving approvals right now within a month, and others are taking 7, 8, 9 months. So we're hopeful that a premium processing will reopen so that we'll have more assurance for those clients who want a fast turnaround time with immigration.
Awesome, thank you. If we're not able to stay in the US at this time, what are the opportunities to come back in a year? And what are your general advice for someone who's graduating now?
There is no disadvantage for applying for a work visa from outside the US. And in fact, if you have more opportunities to work back home, get more achievements, more recognition, that's what you want to do. There's no reason to stay here if you don't have work permission, because you can't build up your O1 case here. You can't use any achievements because you're not permitted to work. So I actually oftentimes advise people, go home, do as much as you possibly can, reach out to your contacts and get as much evidence as you can to prepare for the O1. But keep in mind, there is absolutely no disadvantage. It doesn't matter if you're here or not. Immigration doesn't look at one more favorably than the other.
Great, thank you. This is a very good question. It's about interviews. What are some negotiating points we can bring up while discussing the possibility of H-1B sponsorship with employers during interview? And actually, when is a good time to bring this up?
That's a tough one, because sponsorship, and it's really part of company policies usually. And so it just depends on each company and organization. What I can tell you is their policies are either we sponsor visas or we don't. And this is where the O1 can be beneficial, because if you have an agent style multiple employer O1 and you have a potential employer that does not sponsor but is willing to do whatever he can to help you, obtaining a letter of intent from that employer will get you that work permission to work with that employer on your O1 without having him sponsor you, because you would have an agent petition. So that's one way to sort of work around certain H-1B issues in terms of sponsorship. But from what I've seen, and I've worked with so many people who've been disappointed because just some employers have their own policies. Some say we don't sponsor H-1Bs at all. Some say we will only sponsor H-1Bs for high-level management. Schools have their own, angles on it. Some will do it for only full-time professors, and some will do it for everybody. So this is where the O1 really comes in and could be a useful plan B if you're set on the H-1B.
I think it's a follow-up question about leaving the US right now and to come back later on. Someone mentioned, what are the possibilities of a B1, coming back on a B1, B2 visa? And what is the green card process like for someone who is on an O1 visa?
Okay, so I'm going to split those up. So coming back on a tourist visa, a B1 or a B2 visa is doable. I mean, you're only allowed to come to visit, right? You can't do any meaningful work. You're definitely not allowed to be employed. Even if you're working for a foreign employer, the question is always, where is the work being performed? So coming back on a B1, B2 shouldn't be an issue. The issues that one would face is that temporary intent requirement that I mentioned when I was discussing H1B1s. You have to be able to show that your intention is to only visit temporarily. And if you don't yet have a B1, B2 visa in your passport and you're going to apply for one at the consulate, you're walking in with the presumption already that you're going to overstay and work here illegally. So the onus is on the applicant to always overcome these presumptions. So you want to always make sure that you have evidence of your home ties. So whether it's a job confirmation letter from your employer, whether it's evidence of property ownership, family that lives there, a round trip ticket, bank statements to show that you can financially support yourself while visiting the US. Those are all documents you may want to just bring along with you to the interview and upon entry to the US, should the immigration officer ask you questions about this. Immigration officers generally look at the totality of the circumstances when it comes to tourists entering the US. So if you've been here as a student for the last 4 years and then you had your OPT, so now it's been 5 years, and then you go home for a week, chances of having a hard time re-entering as a tourist are pretty high, because they're going to say, you've been here for the last 5 years, what do you need to come back for as a tourist? I don't really believe you. What are you really going to do? So it's always, the more time spent outside the US, the higher your chances of having no issues upon entry as a tourist. So it's just something to keep in mind. Some people, though, are in circumstances where they're expiring, they have to leave right away, but they didn't have enough time to tie up loose ends and really do need to come back to do that shortly after they're exiting. As long as you bring in strong evidence, most likely you won't have issues. But one thing to mention in the COVID area is that obviously there are also travel restrictions. So people coming in from all the Schengen countries, the UK, China, now Brazil, are restricted. You know, they cannot come in unless they've been quarantined somewhere else for 14 days, or unless, you know, you're a U.S. citizen or you have a U.S. citizen spouse. So, you know, if you come from Mexico, though, there are absolutely no restrictions at all, unless you enter through land. So anyway, these are just considerations to think about. In terms of a green card while you're on an O1, I would like to clarify something, because I think there's this misunderstanding that a visa leads to a green card, and it doesn't. Whether it's an O1, whether it's an H1B, they're totally independent of each other. So it's not as though you're on a visa for X amount of years and then you get qualified for a green card. That's just false. They're treated as complete independent cases. So if you're on an O1, clearly you've qualified for extraordinary ability. There is a green card that's an EB1, that's employment-based first preference, an EB1 extraordinary ability green card. A lot of O1s do apply for that, but they are completely different animals. The EB1 has a much higher standard of extraordinary ability, and it has completely different criteria that you have to meet in order to qualify. Now, in your view, we need the same evidence. So whatever you're collecting for the O1 would then ultimately be used for your green card too. So the awards, the prizes, the coverage in the press, exhibition history, all of these parts of your O1 case absolutely are used for your EB1 green card case, but they're completely different. So generally what I say to people is, qualifying for the EB1, it really is watching your career progress, right? When you have that big break, when you have that, you know, major opportunity or achievement or award in your career, that's generally when you end up qualifying for the EB1 as well. I have some clients who go straight to the EB1 from a student visa because they have an excellent case. And then I have other clients who've been on O1s for 15 years and still just haven't had that big break. They still qualify for the O's, but the EB1 is just outside their grasp because of the standard. So there's that. Now the EB1s are great because you can self-sponsor, so you don't need an employer to sponsor you for a green card. But you can get a green card through employment sponsorship while on an O1 as well. So the green card case is a completely different type of case. They take many years to be processed, and today it's not the best option, because part of these perm, we call them a labor certification, a perm-based green card applications, they test the labor market. The whole point is to document that there are no US workers who are available and qualified for the advertised position for your case. And I'd say 4 months ago, I mean, these were the best cases. Our economy was strong. Very few people were responding to the ads. Green cards were being processed beautifully. But then obviously we have this crash. Unemployment's higher than it's been in, you know, almost a century. And so it's a matter of, well, if we're going to have to test the labor market, there's going to be a lot of changes in the next few months in terms of how employers and immigration lawyers are going to approach those types of green card cases.
Great, thank you, Raquel. What if an employer sponsors my H-1B visa, but I decide to leave the company for some reason?
Absolutely possible. Employers don't own you on these visas, on AHs, Os, any of them. So you always have the freedom to leave your employer. The Trump administration actually issued this new policy, which is quite nice to H-1B holders as well as other non-immigrant visa holders. So you're on an H-1B and you decide your job is terminated, whether it was on your own volition or you were fired. You have a 60-day grace period to either find another employer to sponsor your H-1B and file it, or to leave the country, or to switch to another visa status, as long as your H-1B would have been valid for more than those 60 days, right? So you will have the 60-day grace period to find another position or another alternative. You can't work during that time, but you can have another H-1B employer sponsor your H-1B. You're not subject to a lottery again. Once you've been selected in the lottery, you have 6 years of H-1B status available to you. So you can easily switch to another employer. And another beautiful gem is that you can actually begin employment with the new H-1B employer upon filing the case. You do not need to wait for the approval. So it's a little benefit, so you can start earlier. So you could actually start a new position within 3 weeks of leaving your last H-1B job.
Amazing. So we just have one last question. You briefly mentioned already with H-1B that, the job has to be related to the degree, but I think we have a graduating student who has a job offer from a marketing agency and is worried about whether he or she can take the job offer, given that the job actually is in marketing and the clients are not in the arts.
That's fine. So the client, it depends on her position, right? So if she was going to be a market research analyst, or she could qualify in that position. If she was still going to be, let's say, some sort of arts writer, she could qualify for the H-1B in that position. So it's not so much about the type of company or what the company's focus is. It's really about the position, that job that you're going to be doing. So if you're a lawyer working for an arts agency, as long as you have the law degree, you'll get the H-1B. If you're an arts writer and you're going to be doing arts write-ups for this marketing agency, then you can still get that H-1B as long as you have a degree in that related field as a writer or an arts critic or things like that.
Great. That is all the questions for now. Leonie, thank you so much, Raquel.
You're welcome. My pleasure. Thank you.
All right. Yes, well, thank you, Raquel and Alexis, for that informative presentation. I truly learned a lot, and I hope that you did too. All attendees from today's event will receive a copy of the recording of today's event for your future reference. You will receive that via email. The ARAD program will be hosting various professional development events this summer, beginning with a ARAD alumni networking mixer, which will happen in June. So be on the lookout for an email, as well as you can check the ARAD website and the events tab to find out more information about that soon. We welcome your feedback and suggestions for future events, so feel free to reach out. You can send me an email at aradinternships@tc.columbia.edu. Thank you again to Raquel and Alexis, as well as the TC Alumni Relations Office for partnering with us for today's event. Thank you, all of us, for joining, and we hope that you have a wonderful day. Thank you.
Thank you. Take care.